Welcome to CM Guide podcast series. You know, in huge industries, sometimes the most important rules are kind of hidden away in what seems like really dense, complex legal stuff.
Definitely.
Today, we're taking a deep dive into exactly that. The world of UK construction contracts, statutory adjudication, and security of payment legislation. Our mission to cut straight through any jargon, uncover how these critical laws actually work, why they're so vital,
Yeah.
and maybe find what surprising strategic insights they hold for anyone involved in building projects, even if, you're not a lawyer.
Absolutely. It affects everyone on site, really.
We're going to explore the core ideas, trace their, fascinating development, and most importantly, unpack the real-world implications for your business, your projects.
That's right.
It's an area designed really to ensure fairness and keep things moving, even when disagreements pop up. So let's get into it.
Sounds good.
Okay, so to kick things off, what's the big picture here? When we talk about construction contracts and payment laws in the UK, what's the foundational piece of legislation we need to know about, and what was it actually trying to achieve?
Right. Well, we're mostly talking about the Housing Grants, Construction, and Regeneration Act of 1996. Everyone just calls it the Construction Act, It got a pretty significant update in 2009, and those changes actually came into force in October 2011.
Okay, 1996, updated 2011.
And the goals.
At its heart, this act has two main goals. First, to make sure everyone in the construction supply chain gets paid quickly and fairly.
Right, the money side.
Exactly. And second, to give them a fast, effective way to sort out disagreements. It's often summarized by this quite powerful principle: pay now, argue later.
Pay now, argue later.
Yeah. It's really designed to protect cash flow, fundamentally, and stop entire projects grinding to a halt just because of some payment dispute or, a lengthy legal battle. Pay now, argue later. That's such a striking concept.
Yeah.
Where did that sort of revolutionary idea come from? Was it completely new for construction?
It absolutely was, yeah. This principle largely stemmed from Sir Michael Latham's hugely influential 1994 report, Constructing the Team.
Ah, the Latham report.
That's the one. He proposed a system of what's called statutory adjudication, meaning it's legally mandated, you can't avoid it, to be included in pretty much all standard construction contracts.
Right.
His key recommendations were, quite groundbreaking at the time. Allow any issue to go before an adjudicator.
Any issue, wow.
Make sure those decisions are implemented immediately and only allow appeals after the project is practically finished, so payment isn't held up in the meantime.
Okay, so pay first, appeal later.
Precisely.
Huh.
This act was pretty experimental back then because, honestly, we hadn't really seen this kind of quick interim dispute resolution enforced by law in commercial disagreements before.
So who exactly do these powerful rules apply to them? What does the law actually consider a construction contract for these purposes?
Okay, so the Act defines a construction contract very broadly, really broadly. It includes any agreement for carrying out construction work itself, or even just arranging for others to do it, like a main contractor hiring subcontractors. That's covered.
Okay.
It also covers providing the labor for these operations and even professional services like architectural design, engineering, or surveying work, as long as it relates to construction.
Right, so architects, surveyors, they're in too.
Yes, and construction operations itself is a super wide term. Covers everything from putting up buildings, taking them down, installing systems like heating or electrics, clearing sites, even landscaping.
Landscaping too.
Okay.
It is broad.
Very.
Now, here's where it gets really interesting, I think, especially for people actually working on the ground. I understand there was a big change regarding whether these contracts had to be in writing.
Yes.
What was that all about, and what was the impact?
You're spot on. That was a absolutely crucial amendment in 2011. Really significant. Before that, your right to adjudicate a dispute only applied if your contract was actually in writing.
Only in writing.
Yes. And think about how many informal, maybe handshake agreements happen in construction.
Oftentimes.
Especially with smaller trades, plumbers, electricians, that sort of thing. Before 2011, those folks are potentially left quite vulnerable.
Right.
The 2011 amendments completely abolished that requirement, just got rid of it.
Wow.
This means now even verbal construction contracts are fully covered by the Act. They offer the exact same protections.
So a spoken agreement counts just as much for adjudication.
For the purposes of adjudication and payment rules, yes. It was a game changer because it extended the reach of adjudication significantly, particularly to those smaller and medium-sized companies that, often operate on more informal or verbal agreements.
Yeah, I can imagine.
It certainly led to a noticeable increase in adjudications, make sure everyone plays by the same rules, essentially.
That's a huge expansion. Are there any types of contracts or operations that are still excluded from these rules, even with that broader scope?
Yes, there are some specific carve-outs. You need to be aware of these. For instance, contracts for extracting oil, gas, or minerals, that's generally
Yeah,
out.
resource extraction.
Yeah. Also, the manufacture of building components is usually excluded, unless that contract also includes the installation of those components.
Ah, so if they make it and fit it.
Exactly, like prefabricated units, for example.
Oh.
If the contract covers installation, it's likely in.
Got it.
And an important one, contracts with residential occupiers.
Homeowners.
Yes, people having work done on their own homes. They are generally excluded from the right to adjudicate. However, and this is crucial, this exclusion typically doesn't apply to subcontracts.
Ah. So the plumber working for the main builder on a house extension.
Exactly. That plumber working for the main contractor is usually still covered by the Act's adjudication and payment rules, even though the ultimate client is a residential occupier.
That's a really important distinction.
It is. Keep subcontractors protected.
Okay, let's shift gears a bit to the security of payment side. How exactly does the Construction Act make sure that contractors and subcontractors actually get paid promptly? What are the key steps, the notices involved that everyone needs to be aware of?
Right, the payment mechanism. Well, the Act insists that almost all construction contracts must have a clear procedure. A procedure for figuring out when payments are due, how much is owed, and crucially, a final date for payment for each chunk of work.
So the contract needs to spell it out.
It does. And if a contract doesn't spell it out properly, or if it's missing bits, then a default set of rules automatically kicks in. It's called the Scheme for Construction Contracts.
A default scheme.
Yes, a fallback. It ensures the rules are always there. Key provisions include the right to regular payments, often in stages or by installments.
Makes sense for long projects.
Definitely. And the paying party, whether that's the employer client or a main contractor paying a subby, they must issue a payment notice.
A payment notice, okay.
And it has to be issued no later than 5 days after the payment due date. It must clearly state the amount they think is due, and importantly, how they calculated it.
So transparency in the calculation.
That's the idea. Now, what if they miss that deadline? If the paying party fails to issue that payment notice on time, then the receiving party, say, a subcontractor waiting for payment, can issue their own notice. It's called a default payment notice.
The payee issues it.
Yes. It basically steps in and says, okay, you didn't tell me what you're paying, so here's what I say is due based on my application. It ensures the essential payment information is still formally established.
Right, keeps the process moving. So what if the paying party looks at that notice, either the original one or the default one, and disputes the amount claimed? Can they just decide, nope, not paying that?
No, absolutely not. They can't just withhold payment like that. If they intend to pay less than the amount stated in the payment notice, or the default payment notice if that's what's in play, they have to issue another specific notice. It's called a pay less notice.
A pay less notice. Okay, another key term.
A very critical one. It must contain a detailed explanation of why they're paying less and all the calculations behind that reduced sum.
So full justification needed.
Absolutely. And here's the really crucial bit. It has to be served no later than 7 days before the final date for payment.
7 days before the money's actually due to land in the bank account.
Exactly. And here's the kicker. If a valid payless notice isn't issued on time with all the required detail, the paying party is legally obligated to pay the full amount that was originally notified or applied for. No arguments at that point.
Wow. So even if they genuinely think the work isn't worth that much, if they miss the pay less notice deadline,
they have to pay the full amount stated in the relevant payment notice. It's quite strict.
That sounds like it could create situations where, a contractor gets paid a large sum, even if maybe the work isn't quite up to scratch or the value is genuinely disputed later on. Is there a specific term for that kind of claim where it's more about the procedure than the actual value?
Yes, you've hit on it perfectly. That's precisely what the industry calls a smash and grab adjudication.
Smash and grab. Sounds aggressive.
It can be. It's a tactical, strategic use of adjudication where a contractor or subcontractor seeks to recover unpaid sums purely because the paying party failed to issue a valid payment notice, or, more commonly, a valid pay less notice within those very strict deadlines.
So it ignores the quality of work.
In that specific adjudication, yes. It doesn't focus on the actual true value of the work completed at that stage. It focuses entirely on the procedural error, the failure to serve the right notice on time.
And if they win the smash and grab?
If successful, the contractor is entitled to the full amount claimed in that payment cycle. Imagine a big developer forgets to send a pay less notice on time for a £1 million payment application.
Okay.
The subcontractor can adjudicate, win the smash and grab, and legally demand that £1 million. Even if, perhaps, the work was only really worth half that at the time.
Goodness, but can the developer get that money back if the work really wasn't worth it?
Yes, potentially. The developer can later initiate a separate adjudication, a true value adjudication, to determine what was actually owed based on the work done. But, and this is key, they must first pay the sum awarded in that smash and grab adjudication. Pay now, argue the true value later.
Back to the core principle.
Exactly. It's a powerful mechanism designed to keep cash flowing, prevent payment blockages, but it's very, very unforgiving if you miss a deadline. You have to be on the ball with notices. And related to this, the Act also explicitly outlaws pay when paid or pay when certified clauses.
What are those exactly?
Those are clauses where, say, a main contractor tries to make paying their subcontractor conditional on them first getting paid by the client.
Linking payments down the chain.
Yes. The Act says you can't do that. It's another crucial measure to ensure cash flow isn't unfairly blocked down the supply chain. Everyone's payment should be based on their own contract terms, not someone else's.
Makes sense. And what if payment isn't made according to these rules? If the notices are fine, but the money just doesn't arrive?
If payment isn't made correctly according to the contract and the Act's provisions, the payee, the one waiting for the money, has a significant right. They can suspend all or part of their work.
They can just stop working.
Yes, after giving the required notice, of course. And crucially, they're entitled to recover any reasonable expenses incurred because of that suspension, demobilization, remobilization costs, things like that. And they also get an extension of time for any delay caused.
So suspension is a powerful tool for the payee.
It certainly is a last resort, maybe, but powerful.
With all these detailed rules in place, what are some of the common sort of pitfalls or problems parties still run into with these payment provisions in practice?
Well, common issues often arise when contracts aren't drafted clearly enough. You might get conflicting payment provisions. Perhaps a standard clause says one thing, but a bespoke schedule attached to the contract says something slightly different.
Which one wins?
Courts have generally held that where there's such an inconsistency, the more specific bespoke provision, the one tailored for that specific contract, will usually overrule the general standard clause. But it can cause arguments.
I bet.
Another frequent problem, perhaps surprisingly, is when payment schedules simply run out before the work is actually finished.
Run out. How?
Maybe the schedule only listed payments up to stage 10, but the project actually needs 12 stages to complete. This can mean a contractor isn't technically entitled to further interim payments for stages 11 and 12 until the very final account is settled.
Which could be months later.
Exactly. It can cause significant cash flow issues towards the end of a project. It really highlights the need for consistent, forward-thinking, and, well, carefully drafted terms throughout the entire contract right from day one. You need to think the whole process through.
Absolutely crucial detail there. Okay, now let's talk more about the dispute resolution side, the adjudication mechanism itself. You mentioned it's mandatory and swift. What is it fundamentally, and what makes it such a dominant force in UK construction disputes?
Right, adjudication. It is fundamentally a quick, effective, and importantly, mandatory form of interim dispute resolution.
Interim again, so temporary fix.
Interim is key, yes. The adjudicator's decision is binding for now. It keeps things moving, gets cash flowing, resolves the immediate issue, but it can be re-examined later in court or arbitration if a party really wants the final answer. Think of it as binding unless and until finally determined otherwise.
Okay, and mandatory means?
It means parties to a qualifying construction contract, which we now know includes verbal ones, simply cannot agree to exclude this statutory right. You can't contract out of adjudication.
It's always there as an option.
Always. The entire process, from the initial notification of a dispute to receiving the adjudicator's decision, is designed to be completed within a very, very tight 28-day time frame.
28 days. That's incredibly fast for resolving often complex disputes.
It is. though that can be extended to 42 days if the party starting the process agrees, or even longer if both parties consent. But the default is 28 days.
And why is it so popular?
Its immense popularity stems directly from that speed and its ability to provide a binding decision that helps maintain project momentum and, crucially, keeps that cash flow moving. It cuts through delays.
That's an incredibly tight turnaround. For someone who's maybe never done this before, what are the absolute key phases or steps if they need to actually initiate an adjudication?
You're right, it's fast, so being organized and clear is essential. There are a few core phases you have to follow. First, and this is fundamental, the dispute must have crystallized.
Crystallized. What does that mean in practice?
It means there has to be a clearly defined disagreement. It's not just asking for information or expressing dissatisfaction. It means a formal claim or assertion has been made, and the other party has either clearly rejected it or maybe ignored it for long enough or just hasn't admitted to it. The battle lines need to be drawn, so to speak.
So a clear no or a definite impasse?
Essentially, yes. Once you have that crystallized dispute, the next step is serving a Notice of Adjudication, or NOA.
The NOA.
This is the initial document that formally starts the process. The referring party serves it on the other side, briefly outlining the nature of the dispute, who the parties are, and the remedy or relief being sought, like payment of a specific sum. Clarity in this notice is crucial to avoid arguments later about whether the adjudicator has the power, the jurisdiction to decide the issue.
Okay, notice served. Then what?
Then you need to appoint an adjudicator, and this has to happen within 7 days of serving that notice.
7 days to find and agree on an adjudicator.
Yes. The contract itself might name a specific individual, or perhaps it names an adjudicator nominating body, or A&B organizations like the RICS or the Construction Industry Council.
And if the parties can't agree, or the contract doesn't say?
If they can't agree or there's no mechanism, the referring party can approach any of these A&Bs, pay a fee, and ask them to appoint an adjudicator. That keeps things moving.
Right. So adjudicator appointed within 7 days. What's next?
Also, within that same 7-day period from serving the NOA, the referring party must serve their detailed statement of case. This is called the referral notice.
Referral notice, so the main argument document.
Exactly. It goes to both the newly appointed adjudicator and the responding party. This is where you lay out everything. A full description of the dispute, your arguments, the legal basis, and crucially, all your supporting evidence.
Like what kind of evidence?
Copies of the contract, relevant correspondence, project meeting minutes, site diaries, payment applications, maybe expert reports if needed, witness statements, basically anything that backs up your claim.
Okay, a big bundle of documents usually.
Often, yes. And it's really vital here not to introduce completely new disputes or issues in the referral that weren't at least hinted at or briefly outlined in that initial notice of adjudication. Keep it focused on what you said the dispute was about.
Got it. Keep it consistent. So the referral is served. What happens then?
The responding party usually then gets about 7 days, though the adjudicator can adjust this to submit their detailed response to the referral. They'll put forward their side of the story, their counter-arguments, and often their own bundle of evidence.
Okay, so they get their chance to reply.
Absolutely. The adjudicator might then allow further shorter submissions, like maybe a rejoinder from the referring party replying to the response, or even a surrejoinder from the responding party. But generally, the aim is to get all the key arguments and evidence out quickly.
Is there usually a hearing? Like in court?
It's relatively rare, actually. Most adjudications are decided based on the documents alone, the written submissions and evidence. Hearings can happen if the adjudicator thinks it's necessary, but the default is usually a documents-only process to keep it quick.
Right. And what's the adjudicator's role in all this? Do they just read the papers?
No, they have quite an active role. The adjudicator has a duty to act impartially, obviously, but they can also take the initiative in ascertaining the facts and the law.
Take the initiative. How?
They can request specific documents, they can call meetings and question the parties or their representatives, they can conduct site visits if relevant, and they can even appoint independent experts or legal advisors to help them understand complex issues, though they have to notify the parties if they plan to do that.
So they're actively investigating.
They can be, yes, within the tight timescale, of course.
Yeah.
And then finally comes the decision, sometimes called the award. The adjudicator must issue their binding decision within that 28-day or extended period.
And that's the enforceable bit.
That's the enforceable bit, yes. While it's interim, as we said, it is legally enforceable straight away. It's also generally advisable for the adjudicator to provide reasons for their decision, although it's not always strictly required unless asked for. And they can use something called the slip rule to correct any obvious clerical or typographical errors within 5 days of delivering the award.
Okay, the slip rule for typos. That makes sense.
Nah, just tidying up minor mistakes.
That's still a very detailed process crammed into potentially 28 days.
Oh.
You mentioned keeping the dispute focused. Can you refer more than one dispute to an adjudicator at a time, or is it strictly one issue per adjudication?
Good question. The general rule under the Act is that only one dispute can be referred to an adjudicator in a single adjudication.
Just one.
However, what constitutes a single dispute can sometimes be broader than you might think. A single dispute can actually comprise several sub-issues or claims as long as there's a clear link or connection between them.
Can you give an example?
Sure. A dispute over a final account payment, for instance. That single dispute might involve several sub-issues: claims for extensions of time, arguments about defects, disagreements over the value of variations. They're all components contributing to the overall final account disagreement, so that could likely be dealt with as one dispute.
Right, so if they're all connected.
Exactly. Some contracts do explicitly allow for combining multiple, perhaps unrelated disputes into one adjudication, but that's less common. Generally, the courts tend to adopt what they call a rigorous and common sense approach to figure out what truly constitutes a single dispute. They try not to get bogged down in overly legalistic arguments about it.
Common sense. That's refreshing.
Sometimes.
And what about the at any time, right? You mentioned earlier. Does that mean adjudication can be initiated, even if, say, the parties are already in mediation? Or even if there are court proceedings going on about something else? Or if the contract itself is finished?
Yes, at any time means exactly that. It's very powerful. Contractual pre-dispute procedures like clauses saying you must try mediation first cannot prevent a party from starting an adjudication. Adjudication trumps those.
Really?
Yes. Similarly, even if there are existing court or arbitration proceedings happening, perhaps about a different aspect of the project, that doesn't stop a party from initiating an adjudication on a specific payment dispute or another issue covered by the Act. They are not mutually exclusive routes. Adjudication runs alongside.
So you could have both running.
You could, yes. The Act doesn't impose any limitations on when a notice of intention to adjudicate may be made. And importantly, even if a contract has been formally terminated, disputes that arise under the contract, things that happen while the contract was active, can still be referred to adjudication afterwards.
So termination doesn't kill the right to adjudicate past issues.
Not at all. It's truly a mechanism available whenever a qualifying dispute crystallizes, regardless of other procedures or the contract status.
Okay. Now, an adjudicator's decision is binding, but you've stressed it's only interim. So what happens if a party is really unhappy with that decision and wants to challenge it? How robustly do the courts actually enforce these awards? Do they tend to pick them apart if they look wrong?
That's a really important practical point. The courts, particularly the Specialist Technology and Construction Court, or TCC, take a very, very robust approach to enforcing adjudicator awards.
Robust meaning?
Meaning they strongly favor enforcement. They have a fast-track process specifically for adjudication enforcement, often hearing and deciding cases within 28 days of the application being issued.
So quick enforcement too.
Yes. And here's the crucial thing. The courts will generally enforce the adjudicator's decision even if it seems clear that the adjudicator has made mistakes of fact or even mistakes of law.
Even if they got the law wrong.
Yes. Even if they've applied the law incorrectly or misinterpreted the contract, the court will usually still enforce the decision.
Why? That seems counterintuitive.
It goes back to the Act's primary aim: providing a speedy, effective interim resolution to keep cash flowing. The courts recognize that if they started routinely unpicking decisions based on alleged errors, the whole system would grind to a halt, defeating the pay now, argue later principle. So their firm stance is fundamental to upholding the system. They won't rehear the case or delve into the merits at the enforcement stage.
So challenging an adjudicator's decision sounds incredibly difficult then. On what very limited grounds can a party actually succeed in overturning or, well, preventing the enforcement of an award?
You're absolutely right. It is exceptionally challenging, and successful challenges are rare. They are typically limited to two very narrow grounds. The first is a lack of jurisdiction.
Jurisdiction, we touched on that. What does it mean in this context?
It means the adjudicator fundamentally had no power, no legal authority to adjudicate that specific dispute in the first place. Okay, so examples would be if there was no qualifying construction contract between the parties at all. Although, remember, this now includes verbal contracts, so that's harder to argue now. Or If the dispute hadn't properly crystallized before the notice of adjudication was served,
Timing again.
yes, or if the correct procedures for appointing the adjudicator weren't followed according to the contract or the act. Or, and this is a common one to argue, if the adjudicator went significantly beyond the specific dispute that was referred to them in the notice and referral. They call this acting outside their jurisdiction.
Sticking to the referred dispute.
Exactly. And it also covers the point we discussed earlier. If more than one separate dispute was improperly lumped together in one adjudication without the parties' consent or a clear connection between them, that can also be a jurisdictional challenge.
Okay, so jurisdiction is ground one. What's the second?
The second ground is a material breach of natural justice.
Natural justice. Sounds quite fundamental.
It is. It's about procedural fairness. This involves proving there was a serious procedural irregularity or demonstrable bias during the adjudication process itself.
Like what sort of thing?
For instance, clear evidence that the adjudicator was biased in favor of one party, or more commonly argue that a party wasn't given a fair opportunity to present their case properly or, crucially, to comment on key evidence or arguments, especially if that information was obtained independently by the adjudicator, or if significant new arguments were introduced late in the process that a party couldn't respond to.
So not having a fair chance to respond.
Exactly. It's about ensuring fundamental fairness within that fast-paced, rough-and-ready process. But it needs to be a material breach, meaning it has to be serious enough that it actually could have made a difference to the outcome. Minor procedural hiccups usually won't be enough.
Okay, so jurisdiction and natural justice. Very narrow grounds.
Very narrow indeed. The courts set a high bar for resisting enforcement.
This raises another important practical question. What happens if one of the parties involved becomes insolvent during or after the adjudication? Does that change their ability to adjudicate or, more importantly, to enforce a decision they might win?
Insolvency. Historically, this was a really tricky area. The principles of adjudication pay now, argue later, often seemed completely incompatible with insolvency law, which is all about collecting assets and distributing them fairly amongst all creditors according to set rules.
Yeah, they sound like opposites.
They often were described as fundamentally incompatible. However, a really important landmark Supreme Court decision in 2020 brought much-needed clarity.
What did it say?
It clarified that statutory adjudication and insolvency are compatible in principle. And insolvent parties say a company in liquidation can indeed refer a dispute to adjudication and get a decision.
So they can still use the process.
They can start it, yes. The main challenge, though, comes at the enforcement stage. Courts will very rarely grant enforcement, what's called summary judgment of an adjudicator's award in favor of an insolvent party, especially if the paying party, the solvent one, has a genuine cross-claim or counterclaim against them.
Why not enforce it then?
Because of the risk that if the solvent party pays the adjudicated sum over and then later succeeds in overturning that decision in court or proving their cross-claim, they won't be able to get their money back from the insolvent company. They'd just become another unsecured creditor in the insolvency, likely getting pennies in the pound, if anything. That wouldn't be fair.
Right. The money would vanish into the insolvency pot.
Precisely. So the courts will usually only enforce an award for an insolvent company if that company can provide satisfactory security for the full amount of the award, plus potentially the solvent party's costs of fighting the claim later.
Security like what? Ring-fencing the money?
Exactly like that. Perhaps putting the money into a joint account or providing a bond. Something solid to ensure that if the adjudicator's decision is later overturned, the paying party can recover their money and isn't disadvantaged by the other side's insolvency. It's a very high bar for the insolvent company to meet, designed to balance the principles of adjudication with the fundamental fairness required by insolvency law.
Okay, so insolvency makes enforcement much harder unless security is provided. What about allegations of fraud? Can that be used to challenge an adjudication decision or its enforcement?
Yes, fraud can be raised as a defense to enforcement, but it's generally considered an even higher bar to clear than jurisdiction or natural justice.
Higher than those, wow.
Yes, it requires clear and unambiguous evidence of fraud, demonstrating a real prospect of success in proving that fraud at a final trial. And, importantly, the allegation of fraud must be raised at the earliest reasonable opportunity. You can't sit on it.
And does the fraud have to relate to the adjudication itself?
Generally, yes. If allegations of fraud are properly arguable and, crucially, could not have been realistically raised and dealt with during the adjudication process itself, perhaps the fraud only came to light after the adjudicator's decision was made, then the decision may indeed be deemed invalid and unenforceable by the court.
So if the fraud was part of the dispute presented to the adjudicator.
If it was known about and could have been argued before the adjudicator, it's much less likely to succeed as a defense to enforcement later. Also, it's generally not used as the basis for a claim within adjudication itself. Fraud typically sounds in a different area of law called tort civil wrongs rather than being purely a breach of contract claim, which is what adjudication mainly deals with.
Okay, so fraud is a defense, but a very difficult one.
Extremely difficult, yes. Needs very strong evidence.
Right. So, moving on slightly, if adjudication is intended to be a quicker, maybe more cost-effective alternative to going through the full court process, let's talk about the money side of the adjudication process itself. Who actually pays for what?
Okay, costs. Adjudicators typically charge an hourly rate for their time. This can vary, but often it's in the region of, say, £200 to £300 per hour, plus VAT.
And who pays the adjudicator's bill?
The parties are jointly and severally liable for the adjudicator's fees.
Jointly and severally, meaning?
It means the adjudicator can legally pursue either party for their entire fee if the other party doesn't pay up.
Ah, okay, so the adjudicator is protected.
Yes. However, the adjudicator's decision itself will usually state how their fees should ultimately be split between the parties. Maybe the losing party pays all, or maybe they split it 50-50, or some other proportion based on who won which parts of the dispute. But the initial liability is joint and several.
Okay, and what about the party's own costs? They're lawyers, surveyors, experts.
This is a really significant difference from court litigation. The general rule in adjudication, established by the Act, is that each party pays its own legal fees and other advisor costs, regardless of the outcome.
So even if you win completely, you don't get your legal costs back from the other side.
Correct. You bear your own costs. This each party bears its own costs approach is intended to encourage access to adjudication, making it less daunting financially than potentially facing a huge cost bill if you lose in court.
Right. Lowers the risk a bit.
Exactly. And it's also worth noting that those 2011 amendments we talked about also specifically prohibited what were known as tollant clauses.
Tollant clauses.
Yes, named after a court case. These were sneaky contractual provisions that tried to force one party, usually the subcontractor, to pay all the costs of the adjudication, including the other side's legal fees, regardless of who actually won.
That sounds unfair.
It was seen as deterring valid claims. So the Act now says such clauses are ineffective if they were agreed upon before the notice of adjudication is actually issued. You can agree on cost allocation after the dispute arises, but not beforehand in the contract.
Got it. So tolling clauses are out. Despite it being a quicker process, though, you sometimes hear concerns about the overall cost of adjudication, especially maybe for smaller claims where the legal fees could still be quite high compared to the amount in dispute. How has the industry responded to that?
That's absolutely correct. It has been a concern. While some studies estimated the average cost of the adjudication process itself, just the adjudicator's fees, was around 3% or so of the sums in dispute.
Which doesn't sound too bad.
No, but there were certainly concerning cases highlighted where parties' legal fees disproportionately outweighed the actual claim value. You mentioned an example earlier from commentary, £345,000 in legal costs for a much smaller £23,400 claim. That sort of thing raised eyebrows.
Definitely. So what was done?
In response, various industry bodies like TEXA, the Technology and Construction Solicitors Association, and the Construction Industry Council have introduced specific low-value adjudication schemes.
Low-value schemes.
Yes. These schemes aim to make adjudication more accessible and proportionate for smaller disputes, typically those with a value under, say, £50,000 or maybe £100,000, depending on the scheme.
And how do they make it more affordable?
Primarily by capping the adjudicator's fees. The schemes set fixed, lower fees for the adjudicator's involvement for these smaller claims, making that part of the process much more predictable and affordable.
So cheaper adjudicator fees for small claims, that sounds good.
It is helpful, yes. However, and this is a really crucial point for anyone considering these schemes, they generally do not prescribe any mechanism to limit the costs of the party's own legal representatives.
Ah. So the lawyer's bill isn't capped.
Exactly. While the adjudicator's fee might be capped under a low-value scheme, the cost of getting legal advice, preparing your submissions, gathering evidence, and arguing the case can still be substantial. That remains a significant consideration for businesses, particularly smaller ones, even when using a low-value scheme. The biggest cost element might still be uncapped.
Right, so it helps, but doesn't solve the whole cost issue for legal advice. That's important to know.
Very important.
So, wrapping this all up, what does this all mean for you, the learner, as you navigate the often complex world of construction, or perhaps any other complex industry. It seems like a powerful reminder that sometimes, the quickest path to resolution isn't necessarily about being perfectly right from the absolute start, but maybe about having a clear process and the courage to actually engage with it, even if the result is just a temporary fix like adjudication, just to keep things moving forward. How might adopting a similar pay now, argue later mindset, or even just deeply understanding the specific rules and engagement in your field apply in other areas of your life or your work? Something to think about, perhaps.
Definitely food for thought. Understanding the process is key.
Before you go, please don't forget to share, like, or subscribe. Also have a look at other episodes and visit CM Guide website for better insights on this topic.